Get started. Thank you guys for joining us this morning on the Bayou Connection. We have a special event panel going on for the hour this morning. We've got our attorneys to answer your questions, or if you have any kind of case scenarios you want to run by them, feel free to unmute yourself to ask the question. So we'll have Brent Laliberte, President and CEO of Bayou Title, Rachel Williams, attorney for the Baton Rouge and Zachary offices, and Thomas Hamauei with the Shreveport and Bossier City offices. So if you guys have any questions, feel free to shout them out.
Well, thank everybody for coming. I don't know where my video's at because Thomas and I were just recently on a different meeting and the video was working fine. So you'll just have to trust I'm looking very handsome this morning and I can answer all the questions that you may have, but you just won't be able to see me for whatever reason. So who wants to start? Anybody have any issues that y'all been dealing with? How's the market? We know the market from every indication we have is actually smoking hot right now. Obviously, closings are running well because of the low rates, and apparently buyers and sellers are seeing the benefit and getting very active. So we're very fortunate that it's no matter which market throughout the state that we're located in, they're all somewhat equally hot at this point. Now, obviously, somebody signed in order to ask some questions. So this is where you get to do your part. Although, Stephanie, they're all muted. What are they going to email or chat their questions?
They should be able to unmute themselves on their end. Let's see.
Viola?
Hey, Brent. How you doing?
Pretty good. How about yourself?
Good.
You got a tough one for us? Tough question for us?
Not right now. I'm just listening in. Just listening in.
Okay. Well, obviously, a lot of transactions going on. But I'll give you a couple of things a couple of updates as it relates to the law. I'll give you a chance to maybe formulate your own questions. But the legislative session just ended, and there were actually a few laws that we were kind of supportive of, which did pass. I think everyone realizes with this COVID that because of the immediate necessity, or at least the immediate belief that there was the necessity, John Bell Edwards had passed a proclamation which allowed for remote online notarization, which I guess at first blush seemed to be pretty good, but then once people started thinking about it, looking into it, and kind of drilling down on the fact that we had nothing in place to support any of that, I think very few, very few, and I can say firsthand, Bayou Title didn't do any. Very few transactions were done that way because there were not procedures and safeguards in place. And then plus, it's not just for us to be able to facilitate a closing. What we also need is for the clerks around the state to be able to process it, and we also need for the lenders around the country to be able to realize that they have value. Well, what I can tell you is the last 2 years there was legislation that was filed that never got passed. In this case, there was one that was filed and a compromise bill was passed. So Louisiana will join the ranks of a lot of the states that will have remote online notarization in time, but I think the start date on it is going to be February of 2022, which coincidentally coincides with the timeline, or I guess the kickoff time for all clerks around the state to where they have to be in position to accept online recordation. So February 2022 is going to get us into the 21st century for both of those topics, not only to be able to execute documents remotely through online notarization, but also to be able to assign equal value to digitally signed documents, and for us to be able to transport those documents digitally, remotely to a recorder for them to file it. So that did take place. I tell you, there's one other law which I still want to go back and see how it came about, but and I don't know, Thomas might be old enough. I don't know if Rachel's old enough, but if you remember, we had a period of time where, first of all, we know that all judgments typically, Louisiana judgments prescribe in 10 years. And then there was some change a while back as it related to child support judgments where it said what you needed to do was wait that the 10 years wouldn't run until that child became a major, which meant effectively from the time that it would have value, equal value until they became 28 years old. And that's what we've been operating, for the longest period of time. And what really made it even more difficult was the fact that oftentimes we had no idea how old the child was. So we couldn't even begin to calculate, what the next, when they turned 18 and 10 years from there. So you had to assume the worst case scenario that they were 0 at the time of time the judgment was rendered. Well, coincidentally, we had actually reached out to the state to try to say, hey, look, you think you guys might be able to help us out and at least put some dates of birth or something of value on these judgments? That way it would make it easier for us to distinguish whether it's against this John Doe or my John Doe, because it's really giving us heartache as it relates to that, the 18 years plus 10 years. And their response was, well, that's not the law. It's like, what do you mean that's not the law? That's the law that the whole title industry has been operating under for the last 10 or 15 years. I said, no, that was never the intent. So they actually modified the law this year to clarify that child support judgments were always only intended to run for 10 years and not the 10 years from the age of majority, which has been the principle we've all been operating under, like I said, for at least the last 10 or 15 years. So I'd be anxious to see when that actually comes into play, because I mean, what happens, the process is that it gets voted on, it passed, the governor signs it, and then there's an effective date. And so I think probably in early August will be where it actually gets enacted and registered. I think that what they had mentioned is there's going to be some, like maybe a 2-year sunset period where if the before prescription just flat out kills it, that basically the State Department of Child Services would be able to have 2 years to keep it alive if they wanted to. And so, but I tell you, that may not seem like that big a deal for a lot of people, but I can tell you, being a statewide operation, we see a lot of these around the state. And like I said, it's one of the things, it may just be a common name, so you don't know whether it's your person or not. But even if you find out that it is, you still had to wait until they're 18 plus 10. And the reality of it is, it's just going to be a 10-year from the date of rendering, which is going to be a huge gift back to us. So we'll see. I'm sure all the underwriters will be, because like I said, it's not just like we did a bad reading of it. The whole industry, all the underwriters, everybody, all said the same thing, that it's 18 years plus 10. And it turns out the whole industry was wrong or misread it. So that's going to be a monumental change once it goes into effect.
I do have a question that was sent in by Al Hamauei. He says he keeps seeing commercials for insurance to protect the possible sale or mortgage of your property. He's been told that LifeLock insurance will do that. His question, how could this possibly happen? A fraudulent act not being immediately reversed by the courts.
Well, I noticed the Hamauei. There must be some similarity, right? He's a plant.
No
he's a plant in the audience. He's a plant. And that's Thomas's fault.
Very common name. Very common name.
Yeah. Wait, Thomas, you want to address it?
I will. So yeah, I also have been hearing a lot of radio commercials for protect your title to your home. Thieves are going down to the courthouse. They're stealing the title to your property. I think we got to first look at, what does it mean to have title to a property? A lot of people think that you have a title to your property, which is some sort of document, the same way you would have a title to your car. And by holding up that document, you've somehow proven you own the property. And that's just not the case. Title or ownership of property is more of a known thing than it is a document you can prove, something you know by researching records at the courthouse. It's like for those of us who have Saints season tickets, you know that you hold a ticket in your hand that you get. And then if you want to sell that through a website, you can put in the numbers, they sell it to somebody else, who person prints a piece of paper or gets something on their phone, and your ticket still looks like a ticket like you have in your hand, but it's no good. The same is true of a deed. If I have a deed selling me a piece of property and then I deed it to Brent, I still have my deed, which shows that I own it, but I don't own the property anymore. So what we hear that thieves are doing is they're simply committing identity theft. They are somehow obtaining a signed, witnessed, and notarized document in which the actual owner of the property, let's say me, name has been forged on a document, transferring title to, let's say, the thief. It's not my signature. I didn't sign it. Someone stole my identity or forged my name, either through a fake ID, through getting somebody who's a notary to notarize a document, or stealing somebody's notary seal, or whatever. A document is recorded. So public record evidences that this new person, the thief, owns the property. And then they do something like take a mortgage on the property and cash out and don't make any payment. And then the property gets foreclosed on. Or they then sell it to somebody else and they cash in the money. All the while, I still think I own my property. So that's what it is. How do you stop it? A lot of different ways you can stop it. The first thing is, it's not title insurance. Title insurance that we get at closings does not protect a buyer from something like that. Title insurance is usually protecting you for things that happen prior to your ownership, that are known or unknown things. So identity theft insurance can cover it depending on the company, but the only real way that I know is if you monitor the transactions at a courthouse. And I'm assuming that's what this company claims that they do. They would monitor any parish where you own property, and any time a document is filed with your name on it, a sale, a mortgage, a donation, whatever, they alert you. Just like if you had monitoring on your credit card or any other account, you can pay a company to alert you when something has been done. So that's what it is. That's how you do it. But just like anything else, you could monitor it yourself if you wanted to. You could check the clerk of court's website. You could pay somebody to do it for you. But again, it's monitoring the fraudulent signing of your name to transfer property or even mortgage property that you did not intend to do. But it is not the same thing as the title insurance you obtain at closing.
Can I add some more to that question? Can I add to that?
No question.
All right. Let's say it does happen. You don't have LifeLock. You don't have any insurance or anything. Would you then be able to go to the court and say, this has all been a fraud on my name. I want my property back. If I have to spend some money to do it, but you've just stolen my property. Just because
Absolutely.
I'm in my... Go ahead.
You could, anytime somebody steals your identity, it's a criminal act. And you can definitely call the police and you can file a lawsuit. You'd have to, I think the whole idea of the insurance is the insurance company is saying, we'll pay for that for you. So absolutely, it's a fraudulent transfer. You didn't give up your property. And honestly, it's the fault of the buyer who bought from the fraudulent person or the mortgage company who lent to the fraudulent person. That's their liability, not yours. You may have to hire an attorney to defend yourself, but you can continue to point up to the fact that this isn't my signature. I didn't sign this. I still own it.
And you like, has there been cases like this that's happened where people have gone to court and settled this? You know of anything like that occurring? Because it sounds
I've
so
never
remote.
heard of it going to litigation.
Well, the comment I could make is, I tell you, we've seen a few, and I guess an alarming increase in the number of fraudulent documents being filed of late. You know, and so it is a very real possibility. Now, obviously, if you own it and you don't sell it, you always own it. But like what Thomas and I discussed earlier, how much is, and I think which goes to Al's question, how much money you got to spend to undo that? And that's just a question: who's going to bear the burden of spending the money necessary to prove that I still own which I never sold? You know, and keep in mind too that from an owner's title insurance policy, I mean, you know, you don't often hear it characterized this way, but what title insurance does is insures the past, not the future. So if someone in the future does something, that's not even something that an owner's title policy will cover. Now, I will tell you where we've seen some opportunities, or I guess some occasions of this, has been as relates to tax. You know, you got a lot of tax title sale properties out there. and people are trying to clean things up, cure things. And they'll say, well, you know, this is not insurable, but boy, if we had a quit claim from that party, it would be insurable. And they'll say, okay, give me 5 minutes, I'll be right back. It's like, what? And I can tell you, I had one specific case not that long ago when I was looking at it. I said, you know, something just doesn't look right here. And I kept, you know, it just looked alarming for whatever reason. And so finally I went to one of my underwriters. I said, you know, I'm really kind of wondering whether this is bogus. And immediately they said, oh, it's bogus. All right. I know it's bogus because I've seen these people do it before. And then when I started looking at it, it was, and look, these are the ones that kind of fit in the radar. It's basically a house that was bought a long time ago. It's been sitting there idle, no activity. And then all of a sudden, you know, it just goes back into commerce. Well, as it turned out, there was a quit claim that was executed like in February of last year. So we're talking February 2019 by supposedly this husband and his wife, when in fact, the husband had died 30 years ago and the wife had died 10 years ago. So obviously somebody just realized that there was just this property sitting around and no one was doing anything with it. You know, no one's claiming ownership of it. So who's going to protest? And we've seen an increasing number of alerts from our underwriters saying that's become a very hot ticket all of a sudden, title fraud, where people are trying to do things to transfer title when they in fact aren't even dealing with the owner of the property. And that's a concern.
Another thing sort of somewhat related to that is think about how easy it would be if you can forge a deed, you could forge a mortgage cancellation.
Oh.
So you could have a person who owns a property subject to a mortgage, and without contacting the lender, without paying it off, they forge a request for cancellation, take it down to the clerk of court. The clerk of court marks it canceled. We do a title search. There was a mortgage, but apparently the lender says they've been paid because they signed this cancellation. That person can sell it free and clear when it does have a mortgage on it. So fraudulent documents are always part of a problem that we face.
Yeah, and I tell you, that was one of my big concerns, and I guess still is, as we get away from the actual presentation of original documents, when we keep saying, yeah, we want to be high tech, we want to remotely record things, you know, we want to remotely cancel things, and I can tell you, Jefferson Parish is well positioned to where they probably have, I don't know what John Geckenheimer told me last time, maybe 50 or 60% of their transactions all come via JeffNet. So how hard is it for any one of us to take the promissory note that we executed when we borrowed money way back when and just write the word, and especially, I mean, and what we've kind of done at Bayou now is say, you know what, I'm not going to give you a clean copy of an executed promissory note. I'm going to make you work for it a little bit harder. So I may give it to you. I may have stamped all over it the word copy, because you could otherwise take that and just write the word paid on there and present it to the clerk. And the clerk's going to say, hey, it seems to match up. This is the day that Thomas borrowed the money. This is how much he borrowed. This is, you know, everything is the dollar amount and the rate of interest and everything jives. So it must be legitimate. But, you know, and so that was my concern. And so when I reached out to John and his attorney, Malcolm Meyer, they said, you'd be surprised. The more technologically advanced you become, there's actually less incidents. He said, we had more fraud before. I said, but you think about it. You know, what I'm talking about right now is maybe defacing a promissory note so someone can't take it upon themselves to present it. But what would stop any one of us to say, give me a promissory note in a few minutes and I'll type something up that matches up with the mortgage in the courthouse. And then once I present it, all the clerk does is say, okay, the date's right, the amount's right, the parties are right, everything's right, it must be legitimate. Is it Jocelyn on there? Jocelyn Frank? Is that Jocelyn? We actually had one, and I don't know if she remembers, if that's Jocelyn. If she remembers, we had one, and I'm not going to get into specifics of it, but it was actually a famous person that you would know. And after we did this closing, is that you got on, Jocelyn?
Yeah, this is Russell. Jocelyn had to step out for a few minutes.
Okay, well, you might remember it too, Russell, but it was one that had closed and everything went fine. And then lo and behold, after the fact, there was I'm talking a couple of years later, a mortgage company contacts us and says, I'm owed $900,000, $800,000. Why didn't you guys pay me off? And the first response is, oh shoot, or something like that, right? And then you start looking at it, well, they say, well, that mortgage is canceled. And
Right.
they said, well, we didn't cancel it. So we go look into it. Well, what had happened? And after we did some research, that what had happened, the original mortgage holder had sold the mortgage to someone else. And the problem is what they didn't do was file an assignment. So as it relates to the holder of record, it was still mortgage company ABC. So at some point, someone reached out to ABC and says, look, I want to get a payoff. And their response was, oh, I'm not owed any money. Well, yeah, you're not owed any money because you assigned it to mortgage company XYZ, and that's who all the money is owed to. So what ABC did was basically execute a full cancellation on that mortgage. And then this individual actually mortgaged it a couple times thereafter. So when all this started, coming to light, I reached out to the guy and I said, sir, and he responded. I said, did you pay off that mortgage? He says, no. And he just thought it was the funniest thing ever. I said, well, what happened? He goes, they canceled the mortgage. I said, I understand. I said, but they never reached out to you? He said, well, they reached out to me one time. They said, why aren't you making payments anymore? And he said, well, because the mortgage is canceled. They said, okay, well, thank you very much. Have a nice day. And then a couple of years later, they reached out to him and they said, why aren't you making payments? He says, I'm telling you, the mortgage is canceled. They said, well, would you be so kind to get me a certified copy of the cancellation? He says, of course I would. So they gave him a copy of that too. Well, the problem is it was canceled, but it was never canceled properly. And look, it became a title claim. I don't know ultimately what, I know we didn't write a check because we didn't do anything wrong. Like Thomas kind of alluded to earlier. When we check records, we're looking for a mortgage, and if it says C next to it, that means canceled. It's not our job to figure out whether it was really meant to be canceled or whether or not it was actually canceled by the right party. That's the clerk's job to do that. But that's another situation where, that party is having, their title is affected by this mortgage that was erroneously canceled, which I'm assuming, I didn't go back and check, I'm assuming they probably filed a lawsuit to have the mortgage reinstated, where in fact what needed to happen was mortgage company ABC, who authorized the release of it, basically XYZ needed to sue them and make them whole, because that's where the loss came about, because the person who had no rights to the promissory note is the one who effectively authorized the cancellation of it. And that's pretty scary. And like I said, that's a big number too. That's not just a couple of dollars. That was like $800,000 or $900,000. Does that sound familiar, Russell?
I remember it very well.
Yeah, and I guess she did okay, but he just thought it was the funniest thing. I said, well, I appreciate it, because I talked to the guy. I said, I appreciate you talking to me. He goes, oh, I'll talk to you now. He said, but when the conversation changes, I may quit talking. But he knew deep in his heart that he owed the $800,000, but somebody canceled his mortgage, so he was just kind of hiding behind the idea, hey, it's paid for, go find somebody else, which is not the right answer.
I do have a question that was sent in to me from Chris Nolan in the Slidell area. She's got a question. With the market being so busy right now, they're seeing a lot of competing offers. And I feel like this is kind of something you guys touch on in the Code of Ethics CE class we offer. But how would you recommend going about presenting your client with these multiple offers?
I don't want to dominate. Who wants it?
Anybody want it?
Rachel, you want to chime in?
I mean, I feel like maybe you or Thomas might be better with this one, since y'all do teach classes like that. I've never really.
I guess.
Sure.
Go ahead, Thomas.
Yeah, presenting multiple offers, it's very simple. As an agent, you're required to present all bona fide offers. That's what the law says to your client. And when you get multiple offers, it is your duty, your responsibility, just to present them immediately to your seller or to your buyer, if you're talking about a counter offer, regardless. And the term bona fide, I remember when I first started in the business, wanted to define that. It's an offer where this person who is truly making it intends to pay it. It doesn't have to be reasonable. It doesn't have to be a fair. It's just any offer that you received. And so if you receive multiple offers, you're required to submit those to your client immediately. You submit them all. You'd much rather be in a position where you gave a seller all the offers, even the ones that were a lower sales price or not as good in your opinion, and have them decline or reject those, than hold those out. Because, you know, what makes an offer better or worse is an objective. It's not an objective thing, it's very subjective. But so I want to just kind of right off the heels of that into another portion of the contract, because reading the buy-sell agreement is something I do multiple times a day, over and over again, and we're often asked to interpret the buy-sell agreement. And when you do that enough times, you find the loops, you find the holes, you find the things that I don't think necessarily are as they should be. So I want to touch on 2 points to the buy-sell agreement, because I think that would be most beneficial to agents. You know, the buy-sell agreement has 2 parts that I think are often misunderstood. The first one is how counteroffers relate to or remain with the original offer. So let's say we're in a situation where a buyer makes an offer, and it's whatever the terms we want to imagine in our head, and the seller counteroffers with 5 different terms to be addressed in the counteroffer. Let's say it's seller paying less closing costs, a higher sales price, sale made as is, minimal reservation, and not buying a home warranty, right? Those were things that were all in the original offer, and the seller counters with 5 things that they say, I accept except for these 5 things. That's a counteroffer. Then the buyer responds with counter number 2. And that counter number 2 only addresses, let's say, 2 of those 5 things that the seller addressed. Let's say this buyer says, I'll pay this sales price, and I want you to pay these closing costs. And these are 2 different numbers that were previously in the offer and previously in counteroffer number 1. And the seller accepts that. A lot of people have the misinformation that what they've done is that they have accepted those 2, and that the 3 that were addressed in the original 5 in the counteroffer number 1 are also accepted. But that's not the case. You have to remember, the only elements that are accepted are the original offer and the final counteroffer, unless you say in the last counteroffer, well, we accept the home warranty from counter number 1, we accept the mineral rights, we accept the as is, but we counter just these elements. But too many times I see issues, 5 of them addressed in a counteroffer number 1, only 2 addressed in counteroffer number 2, and people think, yeah, that's just because we accepted those 3, so we didn't need to address them anymore. And the answer is no. You only accepted, when you counter, you reject counteroffer number 1. And so they've rejected all those 5 elements and said only these 2 and the original buy-sell agreement apply. Get that misinterpretation a lot. Any thoughts or questions in response to that from the group?
I've actually had a file where that situation happened, where there was a counter that was rejected, and then when the buyer came back to counter again, they assumed whatever wasn't addressed was automatically accepted, and they lost about $5,000 in closing cost over it. So I think that's a really good important point to make for agents. Now, in those situations when the agents actually talk to each other, they kind of worked it out. So at the end, it all worked out. But at the end of the day, the buyer's agent almost lost their client a ton of money in closing costs to be contributed by the seller. So it happens for sure.
I think another.
Let me go on then. Go ahead.
I think another important thing to keep in mind too is, like Thomas had mentioned, about whether or not it was a bona fide or a real offer. I think keep in mind that as a real estate agent, the real estate commission is going to mandate that you use the proper form and you use it, and correctly. But having said that, your duty, which is even greater than that, is to make sure that all offers are presented. So it's not, I always joke about this when I teach CE classes, it's not anyone's job to be the form police. So even though we know that the real estate commission mandates that if there's a real estate agent involved, that the mandatory purchase agreement be used, if 2 parties among themselves were to make an offer on a cocktail napkin, that could still satisfy the legal requirements as to what an offer is. So as crazy as it may seem, you would have to, and you had multiple offers at one offer, and one of them just happened to be on a cocktail napkin. I think there's the same requirement that be presented as well. Now, I always tell people, as silly as it may seem, that it's on a cocktail napkin. If you find the offer otherwise totally acceptable, what you may want to do is sign the cocktail napkin and say, I accept. Now, I think in a perfect world, you'd like to lock the other party down. Now, obviously, with nowadays with inspection periods, you're really not locked down until you're locked down. But even still, I'd say you lock them down. Then maybe you go back to them and say, look, the real estate commission created this form for a reason. So maybe now that we know that we're in agreement, why don't we take it and transfer it over to the proper form to make sure that it satisfies all the requirements and none of us get in trouble. And to make sure that, because obviously it's, the mandatory form is designed to cover all the issues that people are, that they want to deal with. So, which is a lot more than what's on a typical cocktail napkin.
Thomas, you had something to add on to that before Brent?
I was just going to bring up another issue that I see with contracts often that I think agents would be very wise to stay ahead of. So let's talk briefly about prorations of property taxes and other assessments. It's an element of the buy-sell agreement, which again is something we plug our way through over and over again every day. The contract, the buy-sell agreement says that property taxes are to be prorated for the current year as to the date of closing. Let's talk about what the intention of that is and how we can get ourselves into trouble with that. Let's talk about property taxes. Other than Orleans Parish in Louisiana, we pay our property taxes in all of our other parishes at the end of the year for the year that is concluding, right? So the property taxes are due in December. That's from January 1, 2020 to December 31, 2020, other than Orleans Parish. And when we prorate taxes at closing, what we're in essence saying is we know the seller has owned the property from January 1 to June 4th. We know the seller is responsible for that portion of the year's taxes. So what we do is we deduct money from the seller's proceeds. We give it as a closing credit to the buyer. So the seller gets less money from closing. The buyer brings less money to closing. And in exchange for that, the seller is no longer obligated to pay any of this year's property taxes. And the buyer assumes the responsibility to pay the full bill. But we're doing something when we prorate those taxes. We're assuming that we all know what the annual property tax bill will be in December. And if you don't live in Orleans Parish, I dare you to tell me that right now you can tell me what your annual property tax bill will be 6 months from now. You can't. You don't know if the property is going to be reassessed. You don't know if the millage rate, well, you probably know the millage rate will stay the same unless it's changed in an election, but you don't know what the assessed value of your property is going to be. And so you can't tell me what your annual bill is, yet you're asking a title company to project it. And then when we make an assumption, we're running the risk of being wrong, and we don't know who we're hurting. If we assume the bill is too high, is a higher number than it would eventually end up being 6 months from now, we've hurt the seller because we've taken too much of their money. If we had known it was going to be lower, we would have taken less because the proration would have been smaller. If we take too little, we hurt the buyer, because if we had known it was going to be this big bill, we would have taken more from the seller. So I have voiced this to the Louisiana Real Estate Commission multiple times, and honestly, I don't think they really even understand or didn't understand when I brought it up, is that it needs to be more defined. It's too ambiguous. Property taxes are to be prorated based off of, we'll do it whatever you want to do, off the sales price times the millage rate, off the sales price factoring in a homestead exemption times the millage rate, off the current assessed value at the time of closing, off of the last bill. So what I advise agents to do is stay ahead of that. Let's say you're representing a lady who is selling her family home that she's owned and lived in for 40 years, and she's had the property taxes frozen for 30 of those years, and they haven't increased in 30 years. Yet she's selling the property to a 25-year-old who is going to see a tax increase because the freeze will be lifted as soon as this new buyer buys it, and it goes up in value. Multiply that higher value times the millage rate is going to give this new buyer a higher bill. So what should property taxes be prorated? Well, the contract is what we're going to interpret. The contract says base it off the current assessment. Well, does that mean the current assessment that the seller has with the really low value, or the current year's bill that the buyer's going to pay? How do you penalize this woman who's selling her house because this new buyer doesn't get the same benefits that she gets? And then how do you penalize the buyer by not taking more of the seller's money, because that's a fair proration of what the bill is going to be? Well, you know what? You can answer that for us all. You can write it in the contract. And I advise agents constantly when you write a contract, be prepared. Look out for those things. Again, frozen taxes, homestead exemption or not, new construction. These are all instances where we're going to see a dramatic increase in property taxes from what they previously were to what this new buyer is going to pay. We'll put it at whatever you guys agree to in the contract. That's what we do. Sales price, closing costs, as is, whatever. Whatever you put in the agreement is what we're going to execute off of. So stay ahead of that. You look like a hero in front of your buyer when you say property taxes to be prorated on a number that benefits them. You look like a hero to your seller when you say property taxes to be prorated off of last year's bill, or hey, I'm the seller and I know I don't get a homestead exemption because it's an investment property, but I know my buyer is going to get one, so let's prorate based off of what they're going to end up paying, not what I previously paid. Stay ahead of property tax prorations. You look like a hero in front of your client.
I actually see that come up constantly with my new construction files, and it's never really dawned on me to start encouraging agents to write it into their contract, because essentially what happens is you have a lot of times when you have these new construction contracts, you have what's typically going to be a more sophisticated seller. It's going to be a builder who does this all the time versus the buyer who this could be maybe their first or second time ever buying a piece of real estate property. They're not going to know so much ahead of time. And I always have these builders on the seller side of the transaction make very clear that I am to prorate based on the most recent tax bill, which is just going to be the lot. They do not want us prorating off of what the taxes would likely be once reassessed with the new construction bill. So I see parties getting in fights about this, and they want me to resolve it on my end. Unless they agree otherwise, I'm going to have to use the current tax bill. So I think I'm actually going to start incorporating that as well, Thomas, when I'm talking to my agents, because I see that probably 50% of my new construction files, the parties fighting over how we're going to prorate those taxes.
Yeah, and the beautiful thing is if the agents would address it in the contract, it wouldn't be for us to debate. It wouldn't be for the buyer and the seller to debate.
Yeah.
You'd already decided it for us.
Yeah, that's perfect.
And you talk about new construction, you're talking about a seller who probably paid less than $200 or $300 a year.
Right.
And then you've got a couple $100,000 house. You've got a buyer who's going to be paying $3,000 or $4,000 a year. What do you prorate based off of? We don't care. Just tell us. And the contract is the place to do it early on.
And you can never agree. So that's right. Put it in the contract, and the seller's kind of stuck.
Probably a good idea to ask if we have any more questions from the group. I think we've all sort of covered some of the tidbits that we thought would be beneficial to everyone. Before we get off, do we have any more questions from the group? Feel free to chat it or unmute. Stephanie?
Anyone?
How do you feel?
Tax sale properties. I don't know if you heard me. I'm sorry, Thomas.
No, I didn't. I've been listening to you for too long. Go ahead.
Why can't you insure tax sale properties? Why is Civic Source doing it and y'all can't?
Well, tax sale properties are an interesting thing, something that would take me, something that does take us 2 hours to go over. We have a 2-hour continuing education class just on property taxes and tax sale properties. I'll try to give a summary of what I see as the problem in tax sale properties, but also know that we are closing them and we are insuring tax sale properties currently. The whole idea of a tax sale property is someone owned the property, didn't pay their property taxes, so it went to a tax sale auction. And what people don't know if they've never participated in a tax sale auction is you don't auction to pay more money to pay for the taxes. You offer to pay the same amount of money for a lower percentage of eventual ownership of that property. So who wants to pay Thomas's taxes? It's $1,500 a year. I'll pay it for 100% ownership. I'll pay it for 99% ownership. I'll pay it for 97, etc. The auction is bidding lower percentages, but always to pay the same amount of money. Let's say Hamauei pays Thomas's property taxes, and he continues to pay them for 3 years. There are some statutory requirements that he must send me notice that he's been paying my taxes. Say, hey, buddy, you're about to lose your home if you don't step up and fix your property tax issues. But I don't do anything. And then he basically files a lawsuit against me, which is to what we call quiet the title, to basically say, look, Judge, it's in everybody's best interest for me to get this property because this deadbeat Thomas hadn't paid his taxes in years, and the government needs this money to fulfill all of its obligations financially. But I'm not going to keep doing this for his property. And you convince a judge that you comply with the laws, you got the certified mail, you got the affidavit saying you tried to contact him. Al, I'm giving you ownership of this property. So that's great. Then it's yours. You can sell it. You can do what you want with it. The problem comes in is what happens when we find out that Thomas was the victim of some sort of difficult circumstance. Maybe he's been in a mental institution. Maybe he's instead of Thomas, he's an older lady who didn't know what she was doing. And we have this sympathetic victim, and Al took advantage of this by simply stealing her property, by paying her property taxes for 3 years. That's not right. So she sues to overturn the quieting of the title, the changing of the title from her name into Al's name. And because she's so sympathetic, she wins. But Al doesn't own the property anymore. He sold it to somebody else because he had clear title, and we insured it because it was clear title. And then the judge basically retroactively changes what previously happened and said, no, the transfer from that old lady to Al shouldn't have been valid, and basically goes back in time and changes things. What do we do? Well, title insurance, of course, covers that. So title insurance companies said, well, we're going to stop insuring those because that's too risky. Different insurance companies have come in and gone over the years and tried to insure, but only for small amounts of money or et cetera. So what's happened now is one of the main tax sale buying companies has taken a really diligent effort to fix this. So they've basically gone on their own by buying properties at tax sale, knowing that they couldn't sell them because of the title insurance, and they've done everything possible to exhaust any potential opportunity for somebody to come back and say, I own that property. They took it from me when they shouldn't have. I'm an heir to that person. I'm their mama's cousin, brother's uncle. I'm coming back. That's my property. This company, this tax sale buying company, has notified every potential person. So basically, they're not eliminating the risk. They're just minimizing it. And they say, we feel like we've done so much to cut down the risk of this being a problem, we're going to take the risk. So they went ahead and bought their own title insurance company. And they said, we'll insure it through our own insurance company. And so we write for that insurance company. So now we're closing tax sale properties all across the state. You can buy them. Bayou Title can close them. You can buy title insurance. But because it's a riskier title to a property, because there's still that potential for a higher likelihood of a problem, we charge a higher title insurance premium. Just like if somebody who smokes wants to buy life insurance, it's going to cost them more than someone who lives a life of clean living and less smoking and lower cholesterol, et cetera. They're a more risky risk as a smoker. So we charge them more for life insurance. You're a bad driver with more accidents, you're higher premiums. The same is true for title insurance. That title to that property, that tax sale property, is more likely to have a problem. You can still get insurance, but you have to pay a little bit more for that coverage. And it's called an actual tax sale endorsement. Anytime you hear the word endorsement to title insurance, it's an extension of coverage. Hey, the insurance doesn't usually cover that, but if you pay this a little bit more, we'll endorse or spread additional coverage for that specific issue. That tax sale endorsement will protect this buyer from that problem. And so we're talking about a $150 title insurance policy that's now $1,100. So it's significant, but the coverage grows exponentially.
I just got my video back, so can we start over?
Absolutely.
There he is.
I love to listen to myself talk.
I mean, I'll give you my couple of cents worth of tax sales. Like Thomas mentioned, it's not always 100%. So sometimes people think, well, first of all, well, I bought it at tax sale, I can move in tomorrow. No, that's not what it means. Sometimes what they buy at tax sale is a very small percentage, because if you go back and you read the law literally, what it says is if they're not paying taxes, what the sheriff or the other municipality should do is sell off as big a percentage as necessary to satisfy what is owed. So you could argue that if I have a $300,000 house, why are you ever trying to sell anything more than a couple of percentage interest of my property as opposed to 100%? So we see that though. I mean, I had one the other day. It was 72%. And then, so what they ended up doing was 72%, then they filed suit to quiet title, and then that gave them a 72% interest, but then they had somebody else that had the other remaining 28% interest. So what they then did was filed a petition lawsuit, because in Louisiana, the law says that no one has to own property with someone they don't want to own property with. So they ended up filing a petition lawsuit. And then effectively what that does, it then sends it to a public auction, just like you would a sheriff's sale. And then it goes to the highest bidder. Well, you know, obviously, if someone has had their 72% interest perfected, then they're better positioned to be able to outbid anybody else, because they're kind of playing with house chips. They realize that every dollar they spend, 72 cents of it comes back in their pocket, so they can actually outbid people. So that's kind of the strategy that some people have. They may go into it knowing that, as Thomas mentioned, it may have some problems, and then maybe what they try to do is locate some people and get some quitclaim deeds. Or they might say, hey, I'm going to try to gobble up as much as I can, and then we'll just try to sue to acquire the rest. But it's not for the weak of heart. If you're going to dabble in tax sale properties, you better know what the heck you're doing, because it is kind of living on the edge, you know. And we've seen some people, you know, get out there and get exposed. As Thomas mentioned, there was, when the title insurance first came about, there was one title company doing it, insuring it, which was WFG. And the thing about WFG was doing that, they'd say, well, we'll do it, but we won't extend any coverage beyond $250,000. Well, that became problematic because people were using this as an opportunity to buy houses in areas of the state where once a nice structure was built or renovated, it was going to sell for more than $250,000. So now the other underwriter that we're aligned with, that we can close for or write policies through, is U.S. National, and they'll go up to $1 million. So that kind of creates more of an opportunity to get to a higher level. But as Thomas mentioned, it doesn't come cheap. It's what they call it's a identified risk endorsement. So these underwriters say, look, we're going to take the risk, but you're going to pay me for taking the risk. And look, I mean, just so you know, I mean, this probably isn't a secret to most, but typically most title agencies, when they issue title policies, whatever that premium is, I mean, I'm not saying everybody gets the same thing, but you know, I'll tell you, you know, we get 80% on average of what that premium is. But on those endorsements, we only get 10%. So all of a sudden, there may be an additional, depending upon the size, there may be another $4,000, $5,000, $6,000, $7,000 premium if it's a really big deal, and we're only getting 10%. The underwriter is basically stockpiling the rest of that premium, realizing that they're taking risk, and they expect that at some point they'll get sued, or at some point somebody will surface and say, give me a check and I'll go away. And that's the idea behind it. Is like any insurance contract, it's a matter of identifying what your risk is and what premium you're going to charge in order to be willing to accept that risk. And that's the business model that they're going with right
now. Looks like we're just about out of time. We do have this session recorded, so I will be email blasting it to everyone in case you want to refer back to it. If you have any sort of the situations come up in any of your sales that Thomas or Rachel or Brent had mentioned, and if you do have any other specific questions on that, feel free to email any of them. I'll also include their email address in the email blast recap as well. So with that being said, we're going to go ahead and close it out. Thank you guys so much for joining us this morning. We appreciate all the questions, and look forward to seeing you guys for the next one.
Bye now.
Great one. Thank you.
Hey, Jocelyn.
Hey there. See you guys later.
Thank you, Stephanie.
Thanks.